To welcome everybody to the 2018 Hancock County Prosecutors Debate. I would like to welcome everybody to the Hancock County Library. Before we get started, I have just a couple announcements. If anyone has difficulty hearing, the library has hearing aid devices that they will let you use. As we get going tonight, each of you should have been issued a white postcard. If you have a question, feel free to write that on the card, hold it up, somebody will come and get it. Those questions will be screened, brought up to me, and we will give them to the candidates. Gentlemen, there will be no opening remarks this evening. There are no rebuttals. We will have up to 4 prepared questions and try to take at least 5 questions that are submitted from the audience. We are trying to go right at 1 hour to watch your guys' time as well as our citizens' times. Each of you will have a 2-minute response time to each question. We have a timekeeper in the front row. She's pretty good at what she does. She will tell you at the 1-minute mark, the 10-second mark, and you're done mark. Questions? At the end of our question session, you will have 2 minutes to make closing remarks and deliver the message that you haven't been able to get out in your questions. Okay? We'll introduce Gray Chandler, Brent Eaton, and Robert Elsey. Gentlemen, ready?
Sure. Yes, sir.
We have selected our question order by scientific means called rolling the dice. Gray, this first question is to you. What is your top 3 priorities for your time in office, if elected?
In 2 minutes. I want to bring a proven method of prosecuting sex crimes and drug dealers to Hancock County. Right now we're experiencing, over the last few years, sex crimes that are being filed, major felony sex crimes including rapes and child molests. Only 1/3 of them are getting convictions on the lead count. A lot of them end up pleading to a lesser count, don't go to prison, are dismissed or lost at trial. In Madison County, we see a lot of dangerous crimes, a lot of violent offenses, a lot of drug deals, and a lot of sex crimes. I myself am on the sexual assault response team. I'm a certified child forensic interviewer, and I've handled a lot of the sex crimes filed in Madison County over the last 3.5 years. All of the child molest cases that I've taken to trial, I've won. And I've had defendants receive sentences in excess of 50 years, in excess of 100 years. There is a method to it. You need to have a proper child forensic interview done. You need to have a proper investigation done to find corroborating evidence. And you need to take the case to trial if the defendant is not willing to go to prison, because that's where child molesters belong. And when you pleading a case and giving a child molester house arrest is simply unacceptable. We have to take cases in front of juries and ask them to convict defendants based on the word of a child. That is the reality of a prosecutor sometimes, and we need a prosecutor who's willing to do that. Drug dealing cases also need to be prosecuted more effectively. In the last 2 years, in 2016 and 17, out of 67 major felony, that's level 5 felony and higher drug dealing cases, 33 of those resulted in no prison time. Only 5 resulted in prison time more than 3 years. In Madison County, we start at 3 years. Drug dealers go to prison for a long time. With aggravators, higher level felonies, they can go to jail for 8, 10, 12, 15 years. I regularly prosecute, seek convictions, and put drug dealers behind bars. I'm not talking about addicts, I'm talking about dealers. They're the ones that we need to put in prison to send a message. Addicts we need to rehabilitate, and we have lots of methods to do that. And that was 2 of the 3, but my time is out. Thank you so much.
Thank you. Mr. Eaton, I was going to repeat the question.
Okay, thank you.
What are your top 3 priorities for your time in office?
Very quickly, during the entirety of the time that Mr. Chandler was in the Hancock County Prosecutor's Office, they were 0 for 17 in trying to convict rapists. I'm proud that we were able to turn that around by adding a victim advocate and by having a stop-grant prosecutor so we can effectively begin to prosecute rapists again. We recently prosecuted the county's first rape jury trial conviction for which I can find records. That particular defendant is now serving a 27-year sentence in the Indiana Department of Corrections. I went back all the way to 2002 trying to find the records of another jury trial conviction for rape in this county, and I could not do so. Again, the relevant number is 0 for 17 when they were in the prosecutor's office. What we're going to do is we're going to create a child advocacy center. In fact, what we've done is we already have a 501c3, and there's a cohesive team between the Department of Child Services, law enforcement, and the prosecutor's office. We're going to get that done by the end of 2019. We're going to work with our multidisciplinary team. We're going to bring that to this county, and it's going to improve our ability to prosecute sex crimes. That being said, as your prosecutor, no one has put away more killers, more rapists, more drug dealers, and more child molesters in less time than what I have. So we're going to have a child advocacy center. We're going to continue to be fiscally responsible, and we're going to continue to work with law enforcement to prosecute effectively the narcotics abuse that occurs in our community. We're going to target drug dealers and put them in prison, and we're going to look at addicts and find ways to help them obtain sobriety, because when people obtain sobriety, it's good for public safety. Under my leadership, overdose deaths in Hancock County have decreased by about 25% in the last 2 years, and we're going to continue to make progress. Thank you.
Thank you. Mr. Elsey, what are your top 3 priorities for your time in office?
Sure. Well, I think the very first thing that has to be done is the relationship between local law enforcement and the prosecutor's office has to be restored. One of the reasons I'm running is there's been general dissatisfaction between the way the current prosecutor's office and the police interact and do their business. There needs to be more of a discussion, open and honest, about the tools that the police officers are using in the field. There needs to be discussion about how the police are used in the courtroom. Their time needs to be valued and not wasted. And there just needs to be more of a I hate to say it, but it's true, a cohesive team spirit that just isn't taking place right now. If that happens, you're going to see a whole lot better job done by the police. And when that happens, all of us benefit from that. So that's the number one thing. Second thing, we have to deal with the opioid heroin crisis. It's something that, you know, we've not actually seen before in Hancock County. A lot of places haven't seen it. But we've got to look at it from the perspective of, as a prosecutor's office, we have in our hands, generally speaking, the ability to determine an outcome of a case. Most cases are not tried. Most cases are not pled to the bench. Most cases are resolved by plea agreement. Well, there has to be an opportunity during that time period to come up with an effective way to deal with this, and I don't think we're there yet. Along those lines, my other priority is bringing Rick Culver back into Hancock County. Now, last night we heard that he was a great judge, for the most part, from one of the judicial candidates. I think he's going to be a great chief deputy prosecutor. And if we're going to put somebody in charge of trying to come up with the full spectrum of how we're going to deal with the opiate heroin crisis, Rick Culver's the guy to do it. And so those would be my top 3.
Thank you. Mr. Eaton, this question will go to you first. What alternative sentencing initiatives do you see with the rise of opioid addiction?
Thank you for your question. Before I mention that, I would like to cover something. Every single time that Bob Elsey talks to you, what he's trying to do is to convince you that you, the taxpayers of Hancock County, need to pay the $84,000 in taxes he did not pay when he was defending criminals in our courts.
Nice.
What we need to do for alternative sentencing is we need to work with the drug court. We need to look at the heroin protocol program, and we need to do what we can to help addicts achieve sobriety. I'm proud to serve on the National District Attorneys Association Opioid Crisis Working Group. As part of that group, I actually serve on the treatment subcommittee, and as part of that, we're actually currently working on a paper on aftercare and how to help people once they've been released from aftercare. As part of my work as prosecutor, I've actually worked with probation very closely to have several contracts with treatment providers so that we can help our people that want to achieve sobriety through the court system, because when people achieve sobriety, it's good for public safety. I'm pretty sure, to respond further to what Mr. Elsey said, that when we've convicted the 4 murderers that we've had, law enforcement's been pretty happy with our efforts. When we've been able to effectively prosecute the county's first rape case in about a decade, I'm pretty sure law enforcement was pretty happy with our efforts. When we've been able to prosecute the child molest cases and the drug dealing cases that we have, I'm pretty sure law enforcement's pretty pretty happy with our efforts. Further, those things don't just happen in a vacuum. They happen by teamwork. When we did those things, there was a team working together. There currently is a functioning multidisciplinary team, which is something we brought to the office, which is the first step towards a Child Advocacy Center, and that requires all of us working cohesively together. Additionally, we do the same thing with our drug cases. We centralized our drug cases in one particular prosecutor, and by doing so, there's a consistent way we file those cases. There's a consistent place to go and get the search warrants. We're able to file them quickly and become aggressive in pursuing those cases. Thank you very much.
Thank you. Mr. Elsey, what alternative sentencing initiatives do you see with the rise of the opioid addiction?
Sure. You know, what's been in the papers is the headlines for the last several months is the fact that we've got jail overcrowding. We've got an initiative where we're going to be voting on whether or not we should spend $55 million on a brand new jail. And if that passes, great. And if we get a brand new jail, great. But we have to deal with what we have right now and the beds that we have right now and the number of offenders that we have right now. And the only way to effectively deal with that is to increase the amount of alternative sentencing that we're using. Right now, quite honestly, we're probably underutilizing our current community corrections. It's not that they're not stretched to capacity, but quite frankly, we've got people sitting in jail that could very well be on work release. We've got people on work release that could very well be on home detention. We've got people on home detention that could be on daily reporting. I mean, there are things that can be done to deal with that. But at the same time, you have to understand that when you're dealing with people who are addicts, they're not necessarily ready to just jump into that program. They're not necessarily ready just to have that freedom because, quite honestly, an addict is going to be tempted for quite a while from the time that we get them clean to the time that they can wake up in the morning not thinking about getting high. And for our opiate clients, that's generally marked in years, not weeks or months. So there has to be a form of step down. And that's where community corrections come in. I would love to see us increase the number of work release beds we have, allow people to work their way from work release to home detention, and allow people on home detention to prove that they're ready to take the next step and be a normal, productive member of society, which is really what the rehabilitation process is supposed to be all about.
Thank you. Mr. Chandler, what alternative sentencing initiatives do you see with the rise of opioid addiction?
Fortunately, we're starting to see rehabilitative programming at every step along the way, no matter whether you're incarcerated in prison in the Department of Corrections, since Governor Holcomb has rolled out programs for allow people, inmates in the Department of Corrections to receive the programming that they need, regardless of whether or not it was recommended by the trial court or the prosecutor, all the way to on probation and everything in between. We can offer people services on probation, on house arrest, in work release, and if we end up building a jail with the capabilities, we're going to be able to offer it to them at our local jail as well. And that's very fortunate because at that point we can determine what the appropriate level of restriction is, put them there, and we know that they're going to receive the opportunity to rehabilitate in the programming no matter where they're placed. I'd like to talk more specifically, though, about a couple of things that we do in Madison County that I'd like to bring back to Hancock County, and that is we have something called a continuous sanctions program. We also have reentry court, and I'll start with reentry court. It's a type of problem-solving court. We already have a problem-solving court called drug court, and it's a wonderful program. It's really for the type of offenders who are one step short of going to prison, and we want to give them one last opportunity. Drug court doesn't work like regular court. It's a little more informal. The judge is much more involved, and the offenders have to come in very regularly, but there's a big incentive for them to participate in drug court. You can take the same model and apply it to reentry court, because people that are getting released out of prison to the streets are at a very high risk of recidivism. And if they have an addiction and didn't get any treatment or did get treatment in prison, they're still at a high risk of recidivism because they are going to go right back to the people they hung out with, the places that they used to go, and the things that they used to do without somebody helping them to intervene and to help them come back to society, find a job because they're a felon, or find a place to live because they don't have any money. That's what reentry court does. It's similar to drug court, but it works with offenders being released out of prison. It's one of 4 different types of problem-solving courts that I want to see right here in Hancock County, and I'll help bring that here.
Thank you. Mr. Elsey, this question comes to you first. Currently, for a policeman to arrest someone for DUI who refuses a breath test, a search warrant must be obtained to get a chemical test. What is your viewpoint on this current process?
Well, quite honestly, it's a total boondoggle. For years and years and years, we prosecuted refusal cases without getting a test. Right now, and this is one of those things that I knew if this came up, I don't know how we fit this into the 2 minutes. But this is one of the areas police are absolutely dissatisfied with the prosecutor's office. Sorry, Brent, but they don't like this. Right now, the way it works, if an offender does not agree to take a chemical test, the procedure is the officer is supposed to write up a probable cause affidavit for a search warrant. They're supposed to contact a deputy prosecutor or the prosecutor on call, who then must contact a judge who is on call, who then issues a warrant, who then has the warrant transferred back to the officer, who then has to call an EMT to come and draw the blood of the person who has refused the test. All of this takes time, and these officers are turning what used to be hour and a half, maybe, including paperwork, DUI arrests, into 3- and 4-hour processes. You don't need to have that. We have docu-cams, we have the officer's observations, and they're all very well trained in how to deal with DUI arrests. They've been doing it really since the academy. They've learned how to do field sobriety tests. They know how to testify. If they have probable cause to believe that somebody has actually committed that offense, the person is and refuses a test, that doesn't mean that we're not going to win the case. Having said that, if a person refuses a test, they lose their license for a year. But what's the effect of all of this is we're taking officers off the road for really twice as long as they need to be. If you look at Hancock County, we've got diminishing traffic tickets being written. And why is that? Because fewer stops are being made. And why is that? Because officers are not on the road like they used to be. And this is one of those things that needs to be taken care of.
Thank you. Mr. Chandler, currently for a policeman to arrest someone for DUI who refuses a breath test, a search warrant must be obtained to get a chemical test. What is your viewpoint on this current process?
I think it's appropriate to get a warrant in order to have a number about whether or not somebody is over or under the legal limit when you're making an arrest for operating while intoxicated or operating a vehicle with a 0.08 or higher blood alcohol content. We have the ability to do it. It really doesn't take that long. The warrant process can be streamlined. An electronic warrant process, it should only take a matter of minutes. Now, it does take a little bit longer to have an EMT come and draw the blood. The real problem, what I'm hearing from law enforcement, is not the time that it takes to wait for the EMT to draw the blood, but then they have to take that individual to the hospital to clear them to make sure they're not so intoxicated that they can't be admitted to jail if they need to spend time at the hospital. That's the real issue that law enforcement is having. That's the amount of time that takes up sometimes hours sitting at the hospital, waiting for somebody to come out and clear the individual who has been determined to be over a 0.08. And the jail won't take them until they've been cleared. But the solution is easy. An EMT, somebody who comes and draws your blood, is also qualified to determine whether or not you need medical treatment because of your intoxication level or whether or not you don't. And if you don't, you should be able to be booked in at the jail. The EMT who draws the blood right there can make that decision, saving the police hours sometimes on some of these calls because the police time is valuable. They need to be on the streets. Sometimes when these OWIs occur, it takes the police off the streets for way too long. And so the solution is rather simple, but I disagree with filing cases where they simply refuse and we don't at least try to obtain a warrant, because it is way too easy for a defense attorney in court at trial. And believe me, those are the cases that go to trial. I did OWIs for a very long time. The cases where you have a number, they don't go to trial, because everyone's going to convict that person. But if they refuse, those are the ones that always go to trial. And the time and expense of going to trial and having to have people off the streets to testify and paying them overtime is a whole lot more than getting an EMT there and take the 10 or 20 minutes it takes to get that done. Thank you.
Thank you. Mr. Eaton, currently for a policeman to arrest someone for DUI who refuses a breath test, a search warrant must be obtained to get a chemical test. What is your viewpoint on this current process?
I'm stunned that the defense attorney doesn't want us to have as much evidence. That being said, in this instance, I largely agree with Mr. Chandler. Both of us have tried a lot of DUI cases. Mr. Elsie's tried a lot of DUI cases. I personally have tried hundreds of these types of cases. Here's the bottom line, is that the modern juries expect that there's going to be a number, because that is evidence we can get if we're going to prosecute somebody. If we do not have that piece of evidence, the jury is going to want to know, why do you not have that? Why did you not have the ability to have that? Of course we have the ability to do that if we would have cared enough to get the search warrant, to get the evidence. Convicting somebody of a crime is a very serious thing. We should do what we can to try to get all the evidence we need before we prosecute those cases. back prior to my administration, it was true that there was a lot of difficulty trying to get the search warrant, and that's something I heard a great deal about when I've been prosecutor. And so what we did is we went away from the antiquated fax machines that we used to have. I worked very closely with the judges to be able to do the digital warrants that were spoken of just a few minutes ago. And so the process that used to take us about an hour and a half or so with multiple faxes going back and forth, we can now accomplish in the middle of the night in a few minutes. Usually the thing that takes us the longest is actually calling and getting different people in the chain of command woken up over time and then sending things back. And so while it used to take us an hour and a half or so, we can get done now in just a few minutes. Additionally, I wanted to make a comment that we did not used to have so many local municipalities that would have local ordinance violations. Those used to be filed as state law violations. As a result of those municipalities filing those ordinance violations, of course the infractions are down because now they're being filed in those local areas, not in the state court. Really, it's about evidence. And we've been effective in changing the manner in which we get evidence to get the evidence in a more effective way so we can continue to prosecute these cases. And in so doing, I've been able to save the county tens of thousands of dollars that we used to pay the hospital so that we can save the taxpayers money. I'm very proud of what I've done. Thank you.
Thank you. Mr. Chandler, this question came up last night to the judge candidates. We're going to ask you, what's your viewpoint on cash bonds versus surety bonds and why?
Well, I'm a proponent of cash bonds, and I know in Hancock County when I was here, we used almost exclusively cash bonds, except unless you're out of state. And there definitely is a place and time to use surety bonds, but I'm still a proponent of cash bonds because that cash bond, and we use both in Madison County on a regular basis. And actually, the defendant that's charged in Madison County has the option of posting one or the other, and it's not set by the court in most instances. But when a defendant posts a cash bond, that money is still theirs. It's theirs, and if they're acquitted or the case is dismissed, they get that money back, which if they're innocent, isn't that what should happen? If they're convicted, then that money gets to be applied to the fines and costs or probation user fees, work release fees, community corrections fees. Because they posted that money, then it can be applied to the financial obligations that they have. When you post a surety bond, that money is spent on a service. You're buying a service. You're asking for a surety to ensure your appearance at court, and the fee for that is 10% of the bond. That money's gone, so the defendant doesn't get it back if he's acquitted, and the court doesn't get it, community corrections doesn't get it. The victim in financial crimes, when restitution is owed, doesn't get it back. So for the most part, I think a cash bond is most appropriate. And think about this, if a defendant posts a surety bond, he's not getting the money back. Isn't there a less incentive for him to appear for court than if he had posted a cash bond and he knows that if he sees the case through, he will get that money back? So for the most part, cash bonds are appropriate. There are instances where if people are out of state, or we do need to have somebody who's willing to go out and physically obtain a defendant, which doesn't happen very often, but from time to time, if that's necessary for certain types of offenders, then a surety bond would be appropriate in those situations.
Thank you. Mr. Eaton, what's your viewpoint on cash bonds versus surety bonds and why?
Generally speaking, cash bonds are going to be appropriate in the vast majority of cases because, as he said, it's the case that when somebody pays that bond, it's held in trust by the court. And then oftentimes those funds are used to pay for court costs, for probation fees. So that's a manner to help keep the cost of the taxpayers down. Additionally, with surety bonds, you know, you're paying bondsmen to do those things. And it's just something that we keep the bonds, I think, at a reasonable level. People that should be in jail generally are going to be in jail. The issue really is where's the money going to go? And so it's going to be more or less the same if it's a surety bond or cash bond. The issue is where's the money going to go? And if it goes back into the system to help pay for the cost of the correctional system itself, that seems to be a more effective use of money. In most of the courts I've practiced in, they do use cash bonds, and it is true that generally speaking, when people have a lot of their own money there, it is a greater incentive for them to appear and a lesser incentive for them to fail to appear. Anything we can do to be fiscally responsible and to keep costs down is something we need to really think about doing. It's worked that way for a long time. There are occasions when we may think that, occasionally if it's something we've got to do somebody from out of state or, potentially somebody that we might have to have a bondsman potentially go look at if they were to fail to appear, it may be appropriate to get a surety bond or to explore that option, but in the vast majority of cases in courts I've been around the state of Indiana, cash bonds have been appropriate, and I think that's a good system.
Mr. Elsey, what are your viewpoints on cash bonds versus surety bonds and why?
Well, I agree with both of them. During the 15 and a half years that I was a Hancock County prosecutor, the defense attorney, which I think is twice as long as you've been a prosecutor, we used the cash bond system pretty much in Superior Court 2 exclusively. Now, as what Gray and Brent both said in regards to surety bonds is true. If somebody's out of state, we tend to use a surety bond because in out of state, we have no means of bringing people back to the state of Indiana unless it's a felony case if they decide not to appear on their case. Misdemeanor warrants are not allowed to be served outside of the state of Indiana. So in those cases, surety bonds could be appropriate. Cash bonds are great for the exact same reasons they said. It's money that the offender does not have to lose to the bondsman. Now, having said that, the problem that we're having, and the reason we have some people sitting in jail for long periods of time without being convicted of a crime because they can't make their bond, is we have gone from a system wherein the bond schedule is set with a certain amount of money for the certain type of offense. And it used to be whatever your most serious offense was, that's what your bond was. So if you were a Class D felon, or now a Level 6 felony, and you had some misdemeanors thrown in there, you posted the bond for a Level 6 felony. Today, what we have is a system where they are running these bonds consecutive to one another. So if you're arrested for, let's say, a felony DUI, and your license is suspended, and you have marijuana in the car, well, that's a felony DUI, that is a misdemeanor for driving while suspended, and that is a B misdemeanor for possession of marijuana. So under the accordion style bond, somebody that would in the prior days post $1,000 is now posting $2,000 on the same case. And that's where I think we've gone a little bit awry to ensure that they show up.
Thank you. Mr. Eaton, this is a question from the audience. Would it make your job as a prosecutor easier in the courtroom if law enforcement officers had body cams? Why or why not?
Yes. Good answer. As I mentioned before, prosecutors like evidence, and really everybody should like evidence, defense attorneys, prosecutors, law enforcement themselves. When you have a working body cam that's at the scene, oftentimes it can give you a very real perspective of what happened from the officer's perspective. It's very valuable for us because then sometimes you can see things like demeanor evidence. You can see more or less what the law enforcement officer is saying. One of the greatest things, and John, I remember working with you, is when we began to have the docu-cams, it took a lot of the arguing out of what happened because we had a videotape, we had basically uncontestable evidence about what actually occurred. And so having those things, certainly is really, really great because it helps us to have that tremendous evidence of audio and video of what actually happened at the point in time when it occurred. Not only is it valuable for the prosecution of cases, and not only is there what you can see, there's the verbal and nonverbal evidence you can get from that, but also it can serve as a great way to protect law enforcement against claims that people may make after they've been arrested about different things that may have occurred. And if you have the video, you can really rewind that and see what actually happened. And so our officers do a great job out there in the community. I think body cams could be something that would be very beneficial, and I would support their use to the extent it's financially viable.
Thank you. Mr. Elsey, would it make your job as a prosecutor easier in the courtroom if law enforcement officers had body cams? Why or why not?
It actually makes everybody's job in the courtroom easier. Having worked both sides of the criminal justice system for 30 years plus, you really aren't looking necessarily for, let's see, how can I do this to get this person off, or how can I do that? It's what happened, what is the evidence, just like Brent Eaton said. What is the evidence? How should it be applied in this situation? Body cams are great, docu-cams are great. But when I started prosecuting, we didn't have docu-cams, we didn't have body cams, and yet we still had to win cases. So in regards to cases like refusals, you had to rely on the evidence. And that evidence generally came from a well-trained officer who was motivated and knew how to testify in court. Having said that, it really takes a lot of the guesswork out of it. It makes everybody's job easier because we can all, hey, let's look at the tape. So I think it absolutely can help. It also helps refresh everyone's memory as to what happened. You know, those officers, when they write those reports, it's like I tell people, they're not written in real time. They're written after the officer's off duty. There may be some things that he doesn't remember. I always say the tape is the best evidence. Body cams would allow everybody to basically have a front row seat as to what happened. And I also like to tell people, if you've got somebody on a jury that's never been around anyone who's been intoxicated before, and they look at a video and go, wow, there was something wrong with that guy. That's not a case that ever goes to trial, whether or not you have a blood test or don't have a blood test.
Thank you. Mr. Chandler, would it make your job as a prosecutor easier in the courtroom if law enforcement officers had body cams? Why or why not?
The job of a prosecutor is to seek the truth and ultimately to administer justice, whatever that may be. Oftentimes, when you have conflicting eyewitness testimony, conflicting testimony between what a police officer says happened and what an offender says happened, we trust what the police officer says, but it's a lot easier when you have a video or audio capturing exactly what happened. And for all the reasons just stated, it's an obvious answer, yes. Of course it makes the prosecutor's job easier. The prosecutor's job is to make sure justice is served, is to figure out what happened, to figure out the truth, and that is obviously going to tell us a big part of what happened, a big part of the truth. That being said, we have to remember that it's very costly to put body cams on police officers. And as much as I'd like to see a body camera on every police officer, if you were here for the sheriff candidate debate, I think all 4 of them indicated they'd love to put body cams on all their officers, but it's cost prohibitive. What are the opportunity costs of taking that money and outfitting their deputies with body cameras when most of the agencies in our county already have cameras in their car? A lot of them have body mics already. Are we going to do away with all of that and the money that has been invested in that and replace them with body cameras now? I mean, I don't know the answer to that, but we have to remember that it's very costly. It also raises issue about who has access to that video and that audio, how and when should that information be distributed, who can request it. If you're actually in the video, do you have a right to see it, to have a copy of it? These are questions that need to be answered, and most importantly, we have to remember that just because something is caught on camera doesn't mean that's the whole story either. There have been lots of instances where something is caught on camera, but it doesn't tell the whole story. And we need to be cautious about that and remember that it is a very valuable, important, huge piece of evidence if we were to have it, but it's not the only evidence.
Thank you. Mr. Elsey, this question comes to you first, and you're quickly going to figure out I didn't write it. In regards to Criminal Rule 26 concerning releasing offenders on their own recognizance, how does this impact the prosecutor?
How does it impact the prosecutor? Well, first off, it is very rare to release people on their own recognizance once they've been actually arrested. Now, what has happened is because of our jail situation and the overcrowding we've had there are certain offenses that officers now just write summonses for to people to ensure their appearance in court, whereas they used to be actually handcuffed and taken to jail. And some of those instances are, as I mentioned before, driving while suspended. Possession of marijuana has become one now that we let people be on their own recognizance. And there are a myriad of other minor misdemeanors that allow for that. And unfortunately, right now, we don't have the luxury of not doing that. We've got overflow prisoners in LaGrange County. We have overflow prisoners now in Wayne County. I just found that out here this week. We've got overflow females in Davies County. So the opportunity to utilize bonds instead of releasing people on their own recognizance just isn't available to us until there's a change in the bed space that we have. And whether that happens or not, that's going to be sometime down the road, so I don't see at this point being able to change that system.
Thank you. Mr. Chandler, in regards to Criminal Rule 26 concerning releasing offenders on their own recognizance, how does this impact the prosecutor?
Well, the rule, the Supreme Court is issued requesting judges to consider releasing defendants on their own recognizance if, after being administered the Indiana Risk Assessment System or some type of evidence-based risk assessment, it's determined that they're not a risk to commit a new offense if they were out, they're not a danger to society, and they're not at risk to fail to appear in court. If after given that evidence-based risk assessment tool, they're not a risk, then judges are being encouraged to release them on their own recognizance, of course, with exceptions of murder and treason, I believe. But obviously it affects prosecutors because even though we don't control what bond is, the judges set the bond, the prosecutors make a recommendation, and a lot of times that recommendation is followed by the judges. Our recommendation has to be based on those factors. Are they a risk to fail to appear for court, and are they a danger to society? My position is that the evidence-based risk assessment tools that are used are valuable, and we should consider them, but that should not be the only consideration. A few years ago, I had a level 6 offender in custody requesting a bond review. And during the course of his bond review, I had an opportunity to cross-examine him and see how he answered my questions. I looked at his criminal record, and I sat there and I thought, this is a dangerous man. I literally wrote it on the file. This person is dangerous. I objected to any bond reduction. It was reduced, he got out and committed murder and kidnapping in very short order. On a level 6 offense, he got his bond reduced and got out. Just because it's a low-level offense doesn't mean somebody's not dangerous. So using the risk assessment tools is valuable, but nothing can replace 13 years of prosecutorial experience, cross-examining defendants during bond reduction hearings, looking at criminal records and knowing and being able to articulate for a judge why the man sitting there should not be reduced bond, even though it's a low-level offense. So yeah, we need to use these tools, absolutely, but the prosecutor still has to do his job and object to bond reductions when necessary.
Thank you. Mr. Eaton, in regards to Criminal Rule 26 concerning releasing offenders on their own recognizance, how does this impact the prosecutor?
Well, the IRAS would be a tool to be used. Generally speaking, I don't think it's good for public safety for people that are accused of crimes to be released upon their own recognizance. Generally speaking, as a prosecutor, our position is they got arrested for a reason, and they should have to pay a bond to get out of jail. They get arrested for a reason because they've committed a crime. And generally speaking, they shouldn't just be necessarily let go. There should be a bond, and they should have some assurance as to why they would come, to make sure that they're going to come back, and that's my position. You know, the thing with a lot of that idea is that, you know, we can reduce the overcrowding if we just start letting more people out of jail, and I think that's the wrong way to look at it, because ultimately prosecutors are the lead law enforcement officer in your community, and I think it's bad for public safety to have more people that have committed crime out on our streets. And so I generally, to the extent I possibly can, I'm going to disagree with that. I want you to remember a name. The name would be Mark Emerson. Mark Emerson was accused of domestic violence in our community back in 2014. It was Mr. Chandler's case. He dismissed the case because he didn't have a witness. After he dismissed the case, the Fort Bill Police Department went out and found that witness. They asked him to refile the case. He wouldn't do it. After that, Mr. Emerson subsequently did commit those crimes and, in fact, did commit murder and was apprehended in the state of Minnesota. Thank you.
Mr. Chandler, do you think that Hancock County will eventually have a witness protection program?
Probably not. Witness protection programs are very costly, and I haven't seen them even in such large counties as Marion County, where I worked for a couple years. That's extremely unlikely. Witness protection programs, in my opinion, are mostly completely unnecessary. I've prosecuted a lot of cases, a lot of violent crimes. The only time I've ever seen retaliation where a witness needs to be part of a relocation program is really in Indianapolis, where they had the gangs. And that doesn't mean that witnesses don't need to relocate or be protected, but to enter into a relocation or protection program is not something that Hancock County, as small as we are, is going to be able to do. I will take just a brief moment to respond to Mr. Eaton. It's funny because Mark Emerson was the case that I was talking about where I objected to the reduction of his bond. I objected to his bond being reduced on a level 6 felony, and he was let out and committed that atrocity, that murder. And it never happened that the police came back with the witness and said, refile the case, and I refused to file it. That never happened. That's a lie. Thank you.
Mr. Eaton, do you think that Hancock County will eventually have a witness protection program?
Very briefly, then, if that's to respond very briefly to what was said, then he's calling the Fort Bill Police Department is the one that gave me that information. It was the police chief in Fort Bill that told me. And so I have confidence in him. I have confidence in what he told me. We can look at the record. The record's clear. The case was dismissed. No, I don't think we're going to have a witness protection program. You know, we have had the misfortune of having to prosecute multiple homicides. During my time as prosecutor, we've had 4 different murder trials that we've taken to trial. Every single one of them has been prosecuted effectively and successfully. And, you know, it's not something that just happens elsewhere. We've had witnesses in the course of those cases which, you know, did have problems and actually have had to be relocated within the Department of Correction in different places because of threats from some of the defendants that we prosecuted. It's not necessarily something that we're not going to have a need because there's going to be bad people that will do bad things. The issue really is going to be financial and how it would be that we would have the resources in our law enforcement community to be able to handle that all the time. And so we're all going to have to work cohesively and together to do the very best we can to ensure the safety of our victims. One of the things I'm very proud about is our victim assistance program. We had no victim assistance program prior to me becoming the prosecutor. I worked very hard, as I promised, to bring that. And as a result of bringing that here, then we're able to keep in touch with our victims. We're able to keep track of them. We're able to keep them engaged in the process. It's helped us be more effective in prosecuting all types of cases. And additionally, it's helped us to improve safety because when there are occasions when there may be something going on, we're able to more effectively work with law enforcement because we have a central point of contact for crime victims. Thank you.
Thank you. Mr. Elsey, do you think that Hancock County will eventually have a witness protection program?
Well, if you're talking about like what you see on television and NCIS and that sort of thing, probably not. We don't have a lot of organized crime in Hancock County that we have to hide this one from, you know, Danny Vito or whoever it is. I guess Joe Pesci might be a better example. But quite honestly, we do have victims that need protected, and those tend to be victims of domestic violence. And I'm surprised Brent didn't jump on this because I would have thought he did. They're having a good week of bringing attention to that. But quite honestly, women's shelters have to be available when we are responding to domestic violence situations where women are the victims of a domestic battery. And those shelters have to be in places that are not known to the public. They have to be in places where women and children can go when they need to have a safe haven from certain people. And, you know, none of us are ever going to argue that there aren't people out there that need to be incarcerated, or there aren't people out there that aren't capable of committing horrendous crimes, because there are. Knowing ahead of time who those people are sometimes can be very difficult to do, and I applaud Gray for figuring it out on one. Whether he had anything to do with the other, I have no idea. But one thing we do know is most of the time the women know when they need protection. And so we have to be able to have a system in place, and I believe we do to some extent already, where those people can go and be protected during the process and feel that they don't have to worry about somebody stalking them or showing up unexpectedly in a place where they're vulnerable. So in that regard, I think maybe a little more can be done, but quite honestly, as far as having the, you know, Joe Pesci type person out there that we're going to protect you from, that just doesn't happen in Hancock County.
Thank you. Gentlemen, we've got 2 more questions. Mr. Eaton, this question goes to you. What are top 3 skills or characteristics you think it takes to make a great prosecutor?
3. The first thing you're going to have to be able to do is you're going to have to be able to manage a budget. One of the things that was really a challenge when I came into the prosecutor's office was pretty quickly it became apparent that we were facing about $100,000, about 10–15% actual deficit my very first year. There was a number of changes that we had to make involving personnel, involving salaries, including cutting my own salary, eliminating the supplemental salary. My chief deputy prosecutor, she cut her salary and again eliminated the supplemental salary so that we could be fiscally responsible with the people's money. If you can't do that, then all the dreams and all the things that you think you're going to do aren't going to get past go. And so step 1 is you have to be an effective manager of being able to manage finances. Step 2 is you have to understand the justice system and its needs so you can address it at a macro level. I want to talk briefly about narcotics. One of the things that, when I saw the heroin problem and what it was something that really disturbed me. And so we wanted to change our enforcement. We've got the centralized prosecutor. We're prosecuting drug dealers. We're doing what we can to try to help people achieve sobriety through our alternative sentencing with the heroin protocol and the drug court. And additionally, one of the things we're very proud of is we've been able to work with our schools to bring one of the very first heroin education programs into our schools, with teaming up with Neighborhoods Against Substance Abuse and our county schools to have that nationally recognized program in our schools. Which brings me to the last point, is you have to be able to work with people together. You have to bring people together. I can work 24 hours a day, 7 days a week, 365 days a year, but no prosecutor working that much is going to solve all the problems by themselves. What they have to do is they have to be able to bring people to the table. They have to be able to bring people together to help attack the kind of problems that we have. We have shown a record of doing that with our burgeoning Child Advocacy Center. We've had a record of doing that in our response to the opiate crisis and the response we've had to a lot of serious crimes, and those are the types of skills you need to be an effective prosecutor.
Thank you. Mr. Elsey, what are...
Oh, go ahead.
I like to be fair and read the
Yeah,
question.
I know, but I was going to jump ahead so I can get my 2 minutes going.
I'll give you your 2 minutes, I promise. What are the top 3 skills or characteristics you think it takes to make a great prosecutor?
Okay. The first thing is, obviously, you have to be well-versed in the courtroom. You have to be good at doing trials, because you're going to be the one, when the tough cases come, to actually be the one to stand in front of a jury or convince a judge that this police officer did the right thing in arresting that person for this particular offense. You have to be good at it. The second thing you have to have is leadership. As far as, and Brent's right, you have to bring people together, and unfortunately that's an area where maybe that's not his strong suit. He's good at lots of things, but that's not his strong suit. Like I said from the beginning, the law enforcement community has to be one. We have to be one team. We have to be on the same page. We have to be going forward in the same way. I was so fortunate to be able to work for 15.5 years under Terry Snow, who was that kind of leader, who gave us that kind of prosecutor's office, who worked with law enforcement in a way that, quite frankly, we've not seen since. I'm really the last option to be able to know what that was like and duplicate it. Part of that is you've got to take your own caseload when you become a prosecutor. You've got to lead from the front. And that was something Terry Snow did, and that's something that I plan on doing. But the other thing that I think is vitally important is you have to have good judgment. You are the ones that have to make decisions on who sits in that defendant's chair. Now, a lot of the people earn the right to get there because they do something foolish in front of an officer, whether they have a camera or doesn't have a camera. And they've earned the right to be there. But there are a lot of times where you have to use your judgment in determining whether or not you're going to file a particular case or whether there's enough evidence there to move forward. Jeff Rash told me that he became as good a detective as he became because Terry Snow told him time and again, you don't have enough. You've got to get more. And unfortunately, we read in the paper here, we just released somebody on a child molest case because they didn't have enough before they filed charges, and this man sat in jail for how many months? Judgment has to be there to be able to say, we're not filing this yet until we have enough evidence.
Thank you. Mr. Chandler, what are 3 top skills or characteristics you think it takes to make a great prosecutor?
You have to be a good trial attorney to be a good prosecutor. A prosecutor is a trial attorney first. And if you can't get in the courtroom and try a case and be the lead counsel on a tough case or a high-profile case and win it, then you're not going to be an effective prosecutor. You won't have effective negotiations with defense attorneys. You won't be an effective leader to the other trial prosecutors in the office. Being an effective trial attorney means that you have a lot of other skills that you want to see in a leader. It means you have good written and oral communication skills. It means you're able to articulate to the judge or jury, persuade the jury to see the facts as they ought to be, apply the law, and convict the defendant. It means that you have very good organizational skills. The preparation it takes to try a tough case takes weeks, if not months. And preparing witnesses for trial and going over hundreds of exhibits, sometimes dozens of witnesses, preparing ahead of time takes an enormous amount of organization. And it means you know the law. Being an effective trial attorney means that you know what the law is, you know what the rules of evidence are, you can make proper objections, you can keep out the evidence that needs to be kept out, and you can make sure the evidence that you need to prove your case comes in. Being an effective trial attorney means you have all the skills of a prosecutor, and those skills spill over into every aspect of being a prosecutor. Number 2, work ethic. That's what we need to see in our leaders, is a strong work ethic. If you talk to anybody that's worked with me in the Hancock County Prosecutor's Office or even now in Madison County over the last 11 years and ask them about my work ethic, they're all going to tell you the same thing. People I've worked with are supporting me for a reason, both in Hancock County and in Madison County. And if you don't know my work ethic, maybe perhaps I've been to your door and knocked on your door in the last couple months, or perhaps you know somebody that I have been to their door and knocked on the door, because I've knocked on more doors since January over the last few months than anybody else. And that's because I have a strong work ethic. And finally, integrity. We need leaders who have a strong work ethic, but we need leaders who are going to make the decision for what is right, and not because it helps them or gets their name in the paper or for any other reason.
This will be the last question posed from the audience. Mr. LC, what would you do? It's actually a two-part question. What would you do if you were assigned a case which you were morally opposed? How would you reconcile the conflict between your personal beliefs and the case?
I guess I'm not sure how I understand the question. How do I reconcile, and obviously you don't have the answer to whoever asked the question, what they were asking. In other words, I think you're asking, if I have a moral objection to what the law says, would I pursue a case if the evidence was there to pursue the case? The answer, and I think we're all three going to have to say, and I'd be surprised if either Gray or Brent said anything different, is as a prosecutor, you are obligated to uphold and enforce the laws in the state of Indiana. We're not legislators. We're not judges. We'd be prosecutors. We've been prosecutors. We've all taken those cases as they've come in. If you don't believe in the law of the state of Indiana, then maybe being a prosecutor isn't what you should be doing. If you want to stand up in front of a jury and say, well, here's what the law says, but I want you to do something completely different, then you probably shouldn't be a prosecutor. So I don't see that that would be an issue for any of us or anybody who really wants to be a prosecutor. Now, you said that was a two-part question?
It was a two-part question in the same question.
Okay.
You want me to repeat it?
No. Did I cover? Well, go ahead and repeat it real quick and see if there's anything I missed.
What would you do if you were assigned a case to which you were morally opposed? How would you reconcile the conflict between your personal beliefs and the case?
I think I answered it.
Thank you. Mr. Chandler, what would you do if you were assigned a case to which you were morally opposed? How would you reconcile the conflict between your personal beliefs and the case?
Well, I'm not morally opposed to any of the laws currently enacted by the state of Indiana. So that's the issue of being morally opposed to a law isn't going to happen. So the prosecutor decides if the law applies to a certain set of circumstances and that person should be charged with the crime. That's what the prosecutor, the elected prosecutor, is charged with making that decision. So if I'm morally opposed to somebody being charged with a certain offense, then they're not charged with the offense. As long as you understand that the law is clear and we'll follow the law. But in cases where you're not sure whether or not the facts of the case constitute an offense, that's what the elected prosecutor has been elected to make that call. So this question would be better suited for deputy prosecutors. I am a deputy prosecutor right now, and I can tell you that in my 13 years, I've never been assigned a case that I was morally opposed to prosecuting. And if I would, I wouldn't prosecute it. I'd go to my boss and say, look, for moral reasons, here are the reasons why I believe this person is innocent and shouldn't be prosecuted. And I can't prosecute the case. But that's never happened. When we found out that somebody was innocent, we dismissed the case. It's that simple. We're always in a search for truth, whatever the truth is. And once we find out the truth, we can prosecute accordingly. Thank you.
Thank you. Mr. Eaton, what would you do if you were assigned a case to which you were morally opposed? How would you reconcile the conflict between your personal beliefs and the case?
Well, if it's got to do with the job of the prosecutor is to follow the law. And so what you want to do there is you want to follow the law. And that's the bottom line is, as a prosecutor, your job is to follow the law. That said, during the course of a case, certain evidence may come to light, or you may find or learn something. And I recall when I was a young deputy prosecutor, and I remember having a case, and I remember I was really troubled by it, and I went to an older prosecutor in the office, and at that time, then I looked at him and I said, I really have concerns about if this person is innocent or guilty, and we worked through the case, and at that point, he looked at me and he said, well, if you really have, serious qualms about your ability to proceed because of the facts of the case, and it gives you concerns about the person, that they did not do the crime for which they're accused, then at that point you may want to consider dismissing the case. And so, to agree with the other people up here, the prosecutor's job is to look for the truth. And if you get to a place in the case, it's not to get convictions, it's to find the truth. And so if you do the very best you can, and that's the conclusion you come to, then it may be appropriate to dismiss the case. At the end of the day, the prosecutor's job is to follow the law, and if they do not agree with the law, they can work with our state senator or our state representative to try to attempt to change that law. But at the end of the day, our job is to follow the law and to prosecute it to the best possible way that we possibly can. Thank you.
Thank you. Gentlemen, we've come to that time in the evening where you'll have 2 minutes to address the audience. Mr. Chandler, your 2 minutes starts now.
I start again? Thank you. What do you look for in an elected official? You want somebody who is experienced. You want to put somebody in that position who's already done the job. You look for somebody who is going to work hard, and you look for somebody who's going to do what's right. In any elected position. I'm a career prosecutor, 13 years in prosecution. I started in Marion County. I was a deputy prosecutor here for 8 years. I'm a deputy prosecutor now in Madison County. And Anderson has some really tough crime. In the last few years, I've prosecuted 5 homicides. 3 of those are murders, 3 rapes, a dozen child molest cases, the shootings, the stabbings, the really tough cases in Madison County. But that's not all. Throughout my career, I've done every aspect of the job of prosecutor. I've prosecuted juvenile cases, child support cases. I've done the misdemeanors and infractions and low-level felonies. I've done the OWIs and domestic violence. I literally would be in a position where I'm not asking anybody in the office to do something that I haven't already done and I'm not willing and capable of doing. I will bring with me as a Chief Deputy Tammy Napier, who also has 13 years experience as a deputy prosecutor, 7 of which as a chief deputy prosecutor, 4 years right here in Hancock County. She's tried over 100 jury trials, between us over 150. We have the experience, 26 years in prosecution, over 150 jury trials, and leadership that we're bringing to the prosecutor's office. I already talked to you about my work ethic. The last thing I want to tell you is about making decisions for what's right. If you've ever talked to me for any length of time, you know that before I'm a prosecutor, before I'm a husband or a father, I'm a Christian. And I believe in my faith informs me how to act in all parts of my life. Particularly as a prosecutor, we make decisions because of what's right and just and true and good, and for no other reason. And I will only make decisions for those reasons. We have the experience, we have the work ethic, and the integrity. Thank you.
Thank you. Mr. Eaton, your 2 minutes begins now.
When I walked in the prosecutor's office on January 1, 2015, it was probably in about as worse a shape as it had ever been. It lacked basic office equipment. It didn't have a functioning color copy machine. The budget was upside down to the tune of about $100,000. It had prosecuted 1 murder trial to verdict in the prior 8 years. There was no organized victim assistance. And in order to prosecute the 1 murder trial, they actually had to go and get $50,000 in additional appropriation from the county council to be able to do that. Where are we today? Well, we've come through the last 3.5 years. It's probably the most challenging period of time that the Hancock County Prosecutor's Office has ever had. We've had to prosecute 1, 2, 3, 4 different murders. I'm proud to have been in front of those juries and leading the way to convictions 3 different times in front of juries and murder cases. In fact, I think I'm the first prosecutor in at least 10 years to stand in front of a jury in Hancock County and obtain a conviction. Additionally, we've been able, through a variety of cost-cutting measures, to trim the budget and to bring ourselves back to where we actually are fiscally responsible and we have our act together as far as having enough money to operate and continue our operations. Further, we've been able to add the victim assistance program. It's something I ran on. I was told by somebody it was going to be impossible. We could never do that. We actually got it done within about 90 days of me becoming the elected prosecutor. As a result of that, crime victims in this community have a place to turn. They have somebody to call. They have somebody to go and help them with their problems, to direct them to the resources that they need so they can get the help they need to make it through the criminal process. Additionally, we have a stop grant prosecutor to focus on crimes against women and children so we can try to help those people that are most endangered and most in need in our community. community. In doing all those things, I've been recognized by Neighborhoods Against Substance Abuse I've been awarded by them for my efforts in combating substance abuse in Hancock County, Mothers Against Drunk Driving for my efforts in combating operating while intoxicated cases, and I've been recognized by the Cumberland Police Department as a Crime Fighter of the Year. It's been an honor to serve as your prosecutor for the last 4 years. I hope to continue this work in the years to come. Thank you.
Thank you. Mr. Elsey, your 2 minutes begins now.
Well, when I left the prosecutor's office in 2002 after sharing that with Terry Snow for 16 years, I think the prosecutor's office at that time was in the best shape it had ever been. Over those 16 years that I've practiced privately, there has not been a prosecutor's election season come along where I haven't been asked by law enforcement if I was going to run. And all along I've said no. I'm not going to. My path's gone a different direction. And I fit in as a defense attorney during this time. And quite honestly, I had no great desire necessarily to go back to it. I care about the justice system, and we need good defense attorneys just like we need good prosecutors. But quite honestly, this time, I heard from too many law enforcement officers that it needs to get fixed. Now, again, I wouldn't have done this on my own because really, who cares what Bob Elsey thinks as an individual or as an attorney? All three of us think we're going to be the best prosecutor possible. But quite honestly, when the opportunity came up to bring Rick Culver back to Hancock County to join in that office and to give Hancock County an option to put into place people that have over 15 and a half years as prosecutorial experience, over 15 and a half years as defense attorney experience, and over 29 years as judicial experience, which is almost 70 years when you add it all up. I think it was an opportunity, because I care about the criminal justice system so much, to try and get things right, to try and put this in a situation so that if I'm elected and I ultimately come to the conclusion of that term, that I can say again when I'm done, when I left the office, it was in the best shape it ever was.
Thank you. Gentlemen, I've had the pleasure of working with all three of you in some capacity at the prosecutor's office. I personally want to thank you for your openness tonight. I'd like to thank our citizens of Hancock County for coming out, trying to get the best information they can to become informed voters. Thank you.